I need a little bit of time.
You know what? The devil created me, and I know that devil.
I don't believe that for a second.
Trespassing my creation, my creator's creation. So fuck you.
Oh, okay, thank you.
Mr. Caceres, you are in front of us now because you have a fugitive case. You are wanted out of state of Connecticut for sexual assault. And he has already waived.
Yes, Judge.
And where are we at now?
So, Judge, this was originally set today, but on Friday, on a notification from the demanding jurisdiction, they requested an extension from today to the 3rd. They didn't receive notice, which I don't believe this was addressed on Friday, but they've since corrected the issue with the original fax number not reaching the detective's desk for extradition. And so they've now corrected it where this won't happen again.
So are you saying that Harris County did not fax Connecticut?
No, they did fax Connecticut, but the fax numbers that they sent it to is it has to go through, I can't remember if the name is inspector or adjuster, but there is a figurehead that has to flow through before it reaches the detective's desk, the actual extradition detective. And so on the 3rd attempt, when there was no response, is our sheriff's office reached out to their sheriff's office and finally got someone on the phone. When they were notified that same day, within, I would assume, a couple of hours, because it was still the morning, the detective immediately called Amy, who then notified me, and I talked to the detective within hours of being notified. And from then, they asked an extension to the 3rd to pick him up. For this offense, they have been investigating since 2021, and the warrant issued in 2022 is that they've been pursuing this defendant for quite a long time. And again, this was learned after our approach, after speaking with the detective, is that they weren't aware, they had a possible suspicion he might be in Texas, but they weren't even aware he was here. But due to the severity, the nature of the offense, where, to recap Friday, is that this was closer to a burglary habitation first degree, where sexual assault was committed after forcing himself into the home of someone that he knew. This was not from what they allege, it's not a dating relationship, but someone he's familiar with, is that because of the severity of the offense and the fact that the warrant is so old, is that the detectives believe they are not confident that he will self-surrender. And because they've already confirmed, and they sent another confirmation email this morning that they are able to secure and pick him up this Friday, is that we request no bond for this offense and the extension.
If I may, so whatever the charges might be, it could be murder. It can't be murder because you can't let him out on bond. The point is, he's presumed innocent. So without anything else, he is innocent as he stands here. No evidence is being presented. So if we're talking about the severity of something, he is presumed innocent. He is innocent of that as of right now. Until he gets over there to that jurisdiction, can they find him guilty of that? So presuming he's innocent, talking about the severity of a charge doesn't really have an effect on this fugitive case, because there are two things that he's got in place, two things that he needs to make a decision on, whether to waive or whether to fight formally his extradition. The waiver says, what he agreed to says, they have 14 days. It is ordered for the sheriff to hold him for no more than 14 days of the date this was signed. This is the actual order signed by the court. This is what he agreed to. Signed by him, signed by you, the judge. And so this is the agreement. The fact that somebody didn't send a fax to the correct number, that's not, it doesn't say, but if we send the fax to the wrong number, you get to hold them for 3 extra days. This says 14 days. This is what he signed up for. This is what's ordered. This is what I say should stand, and this is what I say should allowed him to get out today. If they didn't do their due diligence for this, it's not on my client. He signed up for this.
So let me explain to you how things work, Mr. Caceres, is that the 14 days is a courtesy. Statutorily, by statute, we can hold you for 30 days. Normally, and it has become custom that we do 14 days because of the overcrowding that we have in Harris County. We have so many people in custody, 8,000, 9,000, up to 10,000 people at any given time in and out of our jails. And because of that, as a courtesy, we do 14 days. Now, many times I grant extensions, I don't grant extensions. A lot of times, there are several factors that is determinant of whether I grant an extension or not. One of the things are, has there ever been an extension before? Number two, the nature of the charge. Number three, have you ever had a fugitive case before? And so these are things that I look at as to whether to grant an extension or not.
Your Honor, may I please speak?
Well, I don't know. You may want to talk to your lawyer. The thing is this, look, I don't want you to talk about the original case, okay? Because the thing is that I live stream these proceedings, right? And so I don't want you to say something that will, you put your foot into your mouth, because here, the only thing that we're discussing is whether I should set a bond for you to get out, for you to go turn yourself in. That warrant, even if I let you out today, that warrant will eternally be there, and it'll always be out there until you go turn yourself in. The only thing we're discussing now is whether I should set a bond to let you go turn yourself in. And I don't know, because are you a flight risk? I don't know. The only thing I know is that you're charged with a very serious case. It's sexual assault. And so to me, the protection of my community is paramount, number one. Number two, the other question I have is, if we let you out, are you going to go turn yourself in? Everyone tells me that they're going to go do
I have
that.
my family sitting in court, and they are the one, supporting me. And I know 100% they're going to support me to turn myself in. That's why they're still here, and I'm still the last one. And yes, I didn't know about the fugitive warrant that I had. And yes, I'm willing to turn myself in because I'm innocent.
You need to fight those charges regardless, because they're very serious charges. So Dave, what day did you say that they're going to pick?
It's Friday, and I forgot to include, I know typically the court permits over objection for the 3 days, but considering the New Year's Eve is holiday, that's how I also included the.
So are they going to be here Thursday and we reset to Friday?
On Friday. And so that's why the discussion on last Friday was having it on the 6th, but if they're not here by Friday morning, is that you would potentially grant a bond.
So this is what we had planned to do, was I was going to give them an extension until Friday morning, right? If they don't come by Friday in the morning, I'm giving you a PR bond.
I came to visit my family for the holidays. I wasn't able to enjoy that. I'm willing to turn myself in, but I would like to be with my family for the New Year's to start with a strong.
Concern is not my concern. And my only concern is I want you to get back to Connecticut.
And I will, but I need my family. I need to today, as the paper says, I signed for 14 days, and I would like to have a time with my family to look for the bond, to look for them to go forward with turning myself into Connecticut, but not like waiting for Friday.
Let me make one thing clear to you. This isn't about giving you a PR bond. If I were to set you a bond now, it's going to be something substantial, meaning a high bond into the 5 digits to ensure that you go back to Connecticut. This isn't about giving you a PR bond. If they fail to get you by Friday, I'm going to give you a PR bond because they have fallen on their word twice, and I'm not going to do it. Now, if I were to set you a bond now, I mean, it's over 10,000, something like that, to that nature. And because it's a fugitive case, there's no 10%. You're probably going to have to pony up 90 to 100% of it because you are an inherent flight risk because it's a fugitive case. So there's none of this 10% where you pay $1,000 and you're going to get out. No. In these types of cases, when we have fugitive cases, I normally set bonds, 5,000, 10,000. I've set bonds at 50,000. I've set a bond at 100,000, depending on the nature, severity, how many criminal history. So this isn't about just letting you out now willy-nilly. No, I would set you a bond, and it's going to be a substantial bond because I have to know if I'm going to let you out, there's got to be enough blood in there that you're going to actually go back and not just try to flake out. Because if you take off and you don't come back, all that money's gone. So,
Okay, but the 14 days were exactly what I signed for.
remember, it is a courtesy. Statutorily, we can hold you here 30 days.
Okay.
Okay?
To address the legal part of it, if your client is stating that he is withdrawing the waiver after today, then at that point, if you're considering a refusal, then we'll start the governor's warrant process and we'll hold him to 90 days. So if that's what your client is requesting, just in terms of your argument, because you were stating 14 days, that's true. If you want to, at the end, then revoke it, then we'll request an extension to 90 days and get the governor's warrant. So.
Judge, my argument is what he signed, what the order states, and the documents filed in this case. This is what's filed in
I
every
get it.
single-
I understand that. But you know, there's sometimes extenuating circumstances. Things happen.
Not faxing it to a certain person is not a good excuse, Judge. He's sitting there waiting 14 days just because somebody didn't do their job. That should not fall on him and cost him 5 extra days. That's 5 days this man is sitting in jail. 5 extra days just because somebody didn't send a fax to the correct person. This
Get it.
isn't the first time.
It's a courtesy.
I get it. Okay.
We can hold you 30 days. The 14 days, I don't have to give anyone 14 days. I can hold everyone 30 days if I wanted to. 14 is a courtesy. I've told you now that I'm going to give them until Friday. If they don't come here Friday morning, I'm letting you out. And now it's on them. And I don't care. I'm going to give you a free bond on Friday if they don't come pick you up. But if I'm going to set you a bond now, the first thing that's going to happen is you have to withdraw your waiver. All the 14 days that you've accrued so far goes out the window. You lose all the time that you've accrued. If you're unable to make the bond, you've lost all that time. Then they're going to get another, another couple weeks to come get you. So give it till Friday. If they're not here, then I'll give you a PR bond. If they come here by that time, then you get up and you go fight the charges in Connecticut. Now, when you get to Connecticut, you can also, ask for a bond there. They can set you a bond there. But, the money that you would spend here just to get out, it's probably, use that to hire yourself a great lawyer there. Because the thing is that here, it's just a little wait. That in Connecticut, that's what you really got to worry about. This is peanuts. You go there, lean on your family to get you the best lawyer you can get in Connecticut so you can fight that case. That's where the concern should lie.
Thank you, Your Honor.
Remember, when you get on that phone in the jail, every phone call is recorded. Be careful what you say. Be careful who you talk to. There's a lot of jailhouse lawyers over there. They're going to tell you this, they're going to tell you that. Listen to Ricardo. He's going to direct you the best. And then we'll reset this to Friday. If they don't come Friday, I'm giving them a PR bond and I don't give it.
Right, I'm with you, but it was remember, because the holdover issue is that it has to be set.
We'll set it to Monday.
Right.
But
otherwise he's going to be brought up in.
you'll be here Friday, right? Okay, we'll look in the system if they've come get you Friday morning. If not, if they haven't come get you, we got to set a time.
What
time?
Actually, they emailed confirming. Let me see if I can get a time because they have to send it to Central Records for the pickup. So I'll see if they're able to.
We brought you here today so that you could hear what's going on because we wanted to keep you in the loop so you know what's going on.
Thank you, Your Honor.
Okay, that's why we brought you here today so you can hear, so you know you're in the know because this is your case. You need to know what's happening.
Hopefully they'll respond soon. I just emailed the inspector over there. Inspector, so it is inspector. And so hopefully he'll get back to me soon. And then
We can roll it to tomorrow. That way it gives you a little bit more time to get a concrete and firm time.
I have the date, right? If it's just the time, I mean, I have no issue with rolling it just to check the time, but every day that rolls over, he still has to get brought up in the morning really early. So
what I want to do is I want to be able to commit them to a specific time on Friday. So I know I can start working on a PR bond because I'm not giving them until 5 p.m. Friday. It's got to be in the morning and they got to come get you. And if they don't by 10:30, then at that point, I start working the PR bond for you.
Why don't we just set it for 10:30?
I mean, if I get a different time, then obviously I'll email you and I'll email court. And so
It's got to be something reasonable, morning-ish, you
I
know.
think they indicated morning, but obviously until they confirm with our central records.
I want to know from them specifically so that they can say, oh man, you didn't tell us the time and no.
Right. I think
I
I
want-
only had one first specific request for an
I want them
afternoon.
to commit so that they know if they're not here by that time, he's going bye-bye.
The only concern would be is if we don't do it by the time court is done with, we're
That's
not.
why I'm trying to commit them to a time before
Okay,
court
so
is
they can
done
Go after.
so that they can't,
Perfect.
it's on them.
That's
And
okay.
there's no one else that they can blame.
Okay. I'm on board. Yeah.
We can bring them back tomorrow if you want to do maybe, we're off Wednesday, right?
Yes, Judge.
Thursday, whatever you want, or we can email and then you can,
We could email and just, unless they wants to.
Well, I'm emailing the detective now because I emailed the inspector originally. I probably
they
should.
may not respond within, you know,
Well, we could approach on it tomorrow.
Yeah,
off
of course.
docket. We don't need to bring Mr.
That's what I mean is.
done.
Yeah.
That's what we're doing. We're going to pick a time Friday for them to come pick you up so that they are in agreement with. So if they don't come here by that time, you're giving a PR bond.
Thank you so much.
Okay? Okay, man.
Thank you.
Okay. Thank you, Judge.
All right. Mr. Medrano, you were charged with driving while intoxicated. Second offense. You are facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 30 days in jail with credit for the 12 days that you've done. It looks like the state is moving to reduce it to a DWI first. Mr. Medrano, what you need to understand, 1 and 1 make 2. 2 and 1 make 3. So the next time you pick a DWI, it will be a third, and you will be looking at a felony charge, a minimum of 2 years in prison, a maximum of 10 years in prison. Do you understand? If I were you, I wouldn't get in the car even if you've had a sip of alcohol because you were taking a humongous risk. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record and you can never take it off. Do you understand?
Yes.
Is this what you want to do?
Yes.
How do you plead to the offense of driving while intoxicated, guilty or not guilty? I will find you guilty. I'm going to suspend your ability to drive for 1 year. Do not drive until you get a license. Good luck, sir. You can waive the fee and then the surcharge, which is 6,000, so 6,000 plus whatever the court cost is to waive.
Thank you, Your Honor. Maybe
Thank you.
excuse-
Yes, sir. Thanks. Are you sure? It looks different.
He does.
You shaved the beard.
Yes, sir.
You look so much younger. Really. Hi, Mr. Powell. Good to see you.
Good to see you.
Unfortunately, in these circumstances, we had you go to the facility, at the Ed Emmett,
The jail diversion.
right, but
I've been there before and I completed it. I've been
So-
there back in, I want to say, 2022. And from the court number 4. And I stayed there 14 days. And they sent me to a church program and I didn't like it. I don't believe in God. I know who created me. I don't have to believe in God because I know who created me. And I don't want to disrespect you by telling you that.
well, let's hold on, because I don't know what happened on the new cases. So give me a second. Let me have them read out what happened on the new cases so we can see how to go forward, because I don't even know where the new cases happened.
On December 25th, officers were dispatched to a trespasser call at Trinity Lutheran Church in Harris County, Texas. Upon arrival, officers observed the defendant sitting on the steps of the church, screaming obscenities and causing a disturbance. Complaining witness, a security guard employed by the church, advised officers that the defendant came to the church asking for food. When the complaining witness informed the defendant they were not giving out food that day and directed him to 2 nearby locations instead, defendant became belligerent. Complainant stated the defendant threatened him, stating, "I see you don't have a gun, so if we fight, I'm going to kill you." As the defendant was threatening complaining witness, defendant was moving towards him in a fighting stance, causing complainant to feel fear of imminent danger. Complainant stated he told defendant 3 times to leave the location, but defendant refused.
What would you like to do, Shreya?
Well, Judge, my understanding from speaking with Mr. Powell right now is that he's okay keeping the bail as is. And so he's waiving a bail hearing. Is that right, Mr. Powell? I just want to make sure.
No, that's wrong.
Do you want to go back to the Ed Emmett place?
Yes, sir.
You want to try to see?
Medication. So I get my medication.
You-
Because,
What doesn't, it doesn't matter. I just want to know if you want to do that.
yes, sir.
We can try to make it work.
Yes, sir.
Is that
Okay.
something we can do?
So a couple things. To do that, we would have to go through Brad Morse for the mental health, see if Brad even wants to offer that. Then I'd have to get a PR bond with the condition that he gets released there again.
Sure.
And so sort
Do
of
you know how long that program is, Shreya?
So, Judge, it actually could be 10 minutes or it could be 2 weeks. It just depends on the nature of how long they decide to keep him there. It looks like this time they kept him from the 18th until Christmas. I believe he was released on the Christmas Eve. And then this case occurred Christmas morning at about like 7 or 8 a.m.
Okay. So let's see if we can try to make it work. I need a little bit of time.
You know what? The devil created me, and I know that.
I don't believe that for a second.
Trespassing my creation, my creator's creation. So fuck you.
Oh, okay. Thank you, Mr. Bell.
Try to see if we can make it work.
Yes.
Okay. Reach out to.
This is where the judge shifts from routine procedure to a serious warning, a second. The WI may seem manageable, but the next conviction could become a felony with years in prison. One decision behind the wheel can completely change someone's future. What do you think's hold repeat DUI offenders face even harsher penalties?